I also want to get your final takeaway here on on the legal situation. As I just mentioned, the bump stock ban just got blocked by the Fifth Circuit, creating a circuit split that sort of incentivizes the Supreme Court to take up that case. And it seems to me, at least, that the legal arguments are going to be identical between the bump stock ban case and any case against this pistol brace ban. Do you think I'm off base, or is that how you're looking at it too?
I mean, I've seen, I can't remember who the Second Amendment attorney was who said, it might have been Guy Relford, who talked about how there are some differences between the two rules. But I think you're right. The main thrust of the argument, and we saw this in the comments that NSSF submitted on the stabilizing brace, calling it arbitrary and capricious, right? Calling it a violation of the Administrative Procedures Act. This is, again, lawmaking, not rulemaking on the part of the ATF. And when you're taking, again, commonly owned items, somewhere between 10 and 40 million of these braces in the United States, right? That's the Congressional Research estimate.
Yeah, and Alex Bosco says that now ATF put the number between 3 and 7, and now they're saying it's probably closer to 3. Bosco, who again is the inventor and owns the largest company that makes them, thinks it's at least 10. Is where he puts it. So there's obviously, we don't know, but there's estimates all over the place. And even if it is 3 million, that's still a lot of firearms affected and a lot of owners.
It is. And again, the ATF's not arguing that these are dangerous and unusual items, right? They're arguing that putting one of these braces on a pistol turns it into a dangerous and unusual item. Now that the braces themselves are dangerous and unusual. So I think that certainly this is going to get challenged, right? We know SAF is already litigating here, and there are going to be multiple other lawsuits filed as well. I think NSSF is even looking into the possibility of
FRAC
litigation.
And the NRA are filing one.
Right.
As well.
So we are going to see those arguments. And I'm sure you've read the Fifth Circuit's decision on the bump stock ban. And there was kind of an interesting split in the Fifth Circuit, right? There were 13 judges who said, the ban's wrong, but they differed on the reasons. And I think there were 8 that basically said it was a violation of the Administrative Procedures Act. I think there were another 5 who said that it was the rule of lenity. That really is the overriding concern here, that this is so vague. So there are, I think, a couple of live arguments to use, and it may be that one or both of those arguments actually carry the day. I think in this case, both of these things are true. I think the ATF wrote an intentionally vague law that is really impossible for the end user to understand and therefore fully comply with. Mm-hmm. But I think that in doing so, and in writing this really vague interpretation, they stretched the bounds of their own authority, and they crossed over into actually creating a new law and creating a new class of banned firearms. So I'm cautiously optimistic that we'll see a successful challenge here. I also maybe am a little pessimistic that the Supreme Court might not step in right away, right? You talk about the split now on the bump stock ban, but the Fifth Circuit case I spoke with Michael Cargill, who's the plaintiff in that case, for Kamen Company. I think it was 2 weeks ago, and he said his case is actually a little bit further along than like Clark Aposian's and others. His case has already gone to trial. Mm-hmm. So the Supreme Court could even say like, you know what, we don't really have a mature split yet. We've got signs of a split developing, but we'll hold off for a little while.
Interesting.
That's always a possibility, and I think that the question in my mind right now is how much wiggle room, how much leeway, and how much time is the court going to give circuit courts and district courts to get this right before they once again step in and say, okay, we'll repeat it for those who are slow in the back of the classroom, shall not be infringed. Here's what we said in Heller. Here's what we said in McDonald. Here's what we said in Bruin. Pay attention and start to follow it.
Yeah. Although I will say that the Cargill case is actually not a Second Amendment case, right? It's like you mentioned earlier, it's the APA, it's the rule of lenity, which are areas where I think both of those defaults or defects occur with this pistol brace rule as well, and probably with the unfinished receivers rule too. in that like the ATF was all over the place on these things. You know, bump stocks they said were legal, then they decided they're not legal after the fact, and that they were also always illegal. And they did that with both of these other rules. And in fact, the pistol brace one, they've been all over the place on that in, you know, the decades since they first approved the Bosco's initial brace. And so, you know, it's very difficult to understand if you're somebody trying to comply with the rule. Like we just went over, even the two of us don't have a perfect grasp on how it works. And so, you know, I think it's a really ripe for that kind of challenge. And while it took the bump stock ban 4 years before it actually got blocked by a circuit or by an appeals court, I think that ruling itself is going to accelerate the case against the pistol brace. That's my, you know, I'm not a lawyer. We're not lawyers, but that's my feeling from somebody who covers this regularly. Is, you know, in the Fifth Circuit at the very least, there's reason to think that this case might move much more quickly than some of the bump stock ban cases did, precisely because of that bump stock ban precedent.
Yeah, I think that's a pretty good assumption. Obviously, there's no guarantee, right? It's really hard to predict what any individual court will do. But
and it doesn't mean that the Supreme Court is going to step in, as you mentioned.
No, it doesn't. But as you say, I mean, 13-3, even again, if there was that sort of split in favor of the plaintiffs in that case as to what argument prevailed, the 13-3, I think, matters, right? And that should signal that the Fifth Circuit is at least interested in any similar abuses coming out from the ATF. So knock on wood, you're right. And this is something that's going to be on the radar sooner rather than later.